Alex here with a legal nuts and bolts video on win at all costs lawyers. This is going to be a tough topic, and just keep in mind this is not my personal opinion. I don't think that this is great. I don't think that this is how the system should work. But going forward, I do understand why it works this way. I do understand why lawyers think this way. And I do want to say that when it comes to clients, I think they pay their lawyers to win. They don't pay their lawyers to go into court and tell the judge what the law is, generally speaking, and in a fair way sort of present the case as to who should win. No, I think people pay their lawyer to go into court and say what the law is in the exact way that is in their favor. And if it's not, then lie or trick the judge or bend the truth a little bit or whatever and win. That's what they want to do. They pay their lawyer to win. And so there's this culture of win at all costs with attorneys. And that's part of how the adversarial system works. And when it comes to the facts, it's not as bad. Now, it doesn't mean that they don't lie. Well, in a way it does, because they don't look into what the truth is. And to lie, you have to know what the truth is. For you to tell a lie, you have to know what the truth is and say the opposite of that, or not the truth. And lawyers don't even look into it. When their client tells them a list of facts, those lawyers, the win at all cost lawyers, just take it as given. They just assume it's true. And as I mentioned earlier, it's not that they're being tricked, it's that they're not even going to look into what the truth is. Part of it is because that's not what they're paid to do. The client isn't paying them to investigate them. The client is paying them to investigate their opponent. The client is not paying them to spend time interrogating them and deciding whether or not they believe them and all that. The client's paying them to litigate the case in court. And a lot of lawyers, I'm not going to say, what's the word? I'm trying to think of a word. I was going to say it's like a tradition, but it's not more. It's more like a philosophy. It's more like the way they feel the job is supposed to work. It's how things are supposed to be to them. It's not like they don't know, and it's not like they don't know their clients lie. It's not like they don't know that it's not great when they represent a person who is deceptive. It's just the way they feel that that's the way the system is supposed to work, and so they go with it. They run with it. The problem comes, I think, mainly in child custody cases. When it comes down to money, if both sides have a win-at-all-cost lawyer, both sides are going to tell the court things that aren't true, partially because the clients lied and partially because they needed to twist the law a little bit or even just flat out lie about what the law was. And most judges are prepared for that, and they're expecting that, and they know that, and so they don't just take everything that's fed to them. They don't just let the lawyers just spoon feed BS to them. They look into the actual law, and they do their research, and they rule accordingly. But in child custody cases, this isn't necessarily always the case. And the only reason I can say this with confidence is because it happened to me. My first judge was not a win-at-all-cost lawyer. And I'm not 100% sure about this. I'm only guessing that this is the case because it seemed to me that he had a different perspective as to what he thought lawyers were doing in his courtroom. And I'm pretty sure that that was because he himself was not a win-at-all-cost lawyer. I call him sometimes mini judge lawyers. I think he was one of those lawyers. He was like a judge before the judge. And I think when his clients made assertions on what the facts were, I think he looked into them. I think he investigated them. I think he wanted to be convinced that they were true. And if they were, I think he would then apply the law in a way that it was meant to be applied and try to win the case. And I don't think that he understood that there was another type of lawyer out there. I don't think he understood that not all lawyers were like that. And so when my ex's attorney would make assertions in court, I realize now in hindsight, looking back, that he seemed to think that her lawyer vetted all the allegations, that her lawyer looked into all the things she was saying. They were crazy statements, but they must be true. Her lawyer must have made sure before coming into his courtroom to ask that her request was reasonable. But he was wrong. It was far from, the requests were far from reasonable. She was trying to win at all costs. She took what her client said is true and she just went with it. She knowingly made arguments that were not in the best interest of the child. And I just don't think he could get his head around that. And it made it very hard for me, representing myself, to beat that. I think it wouldn't have been so bad if I had an attorney, because he would have assumed that my attorney was making requests that were also in the best interest of my son. And I think he was also the type of judge who was fond of two attorneys, because I think he was the type that would just talk to them in chambers and say, you two need to figure out what's best for this kid. To hell with your clients. Figure out what's best for this kid. Make your client agree to it and send it in. He was very big on, I hate to use the word coerce, but in my opinion, he was very big on coercing settlement. And I use the word coerce because I've read the judicial canon in Nevada, and there specifically is a rule against coercing settlement. But I think that he would do that because, in his eyes, the ends justified the means. Even though it wasn't how the law was supposed to work, he had an opinion that he thought that's how it should work, and so he pushed that opinion. So in my case, and I'm sure other cases where there was just one attorney, I'm sure he made terrible mistakes based on this belief that attorneys were vetting their clients' statements and allegations and looking into them and making sure they were true, and that they were making requests that they felt sincerely were in the best interest of the kids. The reality of it couldn't be further from the truth. There are lawyers out there who will win at all costs, and there are lawyers out there who will say things and ask for things that will damage children. The next statement I'm going to make is really hard to make, but I think these lawyers think that's their job. And I'm sure in the back of their mind, the good ones that are moral and honest and just, yet still follow this win at all cost mentality, hope that the judge will rule against him. And it's so weird to say that, because to a normal person, they're going to say, wait. If you want to be ruled against, why don't you just tell the judge the truth, that your client is insane and that they're asking for insane things, and to deny it. Most people think, for the sake of children, that that should be done, and it should, but that's not how win at all cost mentality works. And other people will say, okay, fine, don't do that, but just fire your client, or just dump the client. Get off the case so that the child doesn't suffer. But that doesn't happen either. I mean, some lawyers will do that. Some lawyers in the child custody, in the family law area will do that. They will win at all costs to a certain extent. And if their client crosses a certain line that they just cannot stomach, they cannot allow a child to suffer at their hand, they will. Now, none of them are going to go in court and say, my client's a liar, rule against him. That's not going to happen. But they will dump the client. That will happen. They'll say something like, my client and I have a difference of ideological opinion. We cannot work together. I will not represent him. In any other kind of case, it's frowned upon very much, especially in criminal cases, because of that whole principle that no matter how bad no matter how bad a crime a person has committed, they deserve representation. It's frowned upon even in those cases, no matter how disgusting or vile the defendant is in a criminal case. A lawyer will be looked down upon if they try and say that they can't represent them because of what they've done and all that stuff. But when it comes to child custody cases, it's a whole different thing, because a child is going to suffer, and so there are some attorneys that will just dump their client. But not all of them. And in my case, that happened to me. And so I hope I didn't go too long in this video. I'm sure that this will touch a lot of my viewers, and I'm sure there's going to be a lot of comments on it. There's just this, and I'm not really trying to provoke some kind of movement from this video. I'm not really trying to say that there should be a solution, that we should just change things. I think really the solution here is that judges need to know that attorneys will come into court and request things that are harmful to a child. They need to know that when they're sitting on the bench, and they need to not just allow attorneys to just spoon-feed them nonsense. They need to let the attorney argue their ridiculous thing, let them make that ridiculous request, and deny it. And the system wouldn't be so bad if all of the judges knew that there are attorneys that do this, and I think most of them do. I just think in my case, my first judge did not. And I think that is where a tremendous amount of suffering, of my child's suffering and mine also to see him suffer, flowed from. So when I do my docket series, I'm going to cover this in detail in each of the videos where it comes up as to why I think the judge ruled the way he did. There were a lot of situations where I can use my own example to show this. With now, I'm going to go ahead and end this video, and I'll see you guys next time.